Good afternoon. This is Greg Lois, and we're starting our presentation on scheduled loss of use and disability duration guidelines in New York. And I'm hoping this sounds okay. Oh, yep, testing. It does sound okay. Good. Getting a thumbs up right here. So good afternoon. I hope you had a great Memorial Day weekend and you're ready to learn about scheduled loss of use in New York. So let's get to our housekeeping slides. First slide is going to remind everyone that this is an instructional purpose only presentation, and I am not answering or providing legal advice as to any specific matter. Also, this is completely and totally live. It makes it so much more fun if you ask questions. Please do. I love questions. Please ask me as many questions as you'd like. You can type them into the box. That's why you're attending live, right? I will answer as many as I can. I'll only say your first name so you know I'm answering your question. I will then repeat the question so the entire audience can hear it, and then I will do my best to answer your question. So today, what are we talking about? Well, we're talking about New York workers' compensation, and we're talking about how do we value cases on a scheduled loss of use, and what are the exposure principles that we apply here at LOIS Law Firm when we are reviewing these cases. We're going to talk quickly about maximum medical improvement because that is the foundation to moving a case into a stipulated scheduled loss of use finding. I'm going to talk about using the disability duration guidelines, and then I'm going to talk about how we as attorneys try to add value by giving you information you can use, and that is our exposure analysis. That's what we'll be talking about with our clients. So let's begin with a quick recap of what is maximum medical improvement. Well, often called MMI, it means that the claimant has really reached a medical plateau. Now, in New York, they can still be entitled to ongoing palliative care, but it means that curative care has essentially come to an end. Now, New York has a strange thing in its disability duration guidelines where it says that a claimant cannot reach maximum medical improvement in less than 6 months unless the parties agree. The disability duration guidelines also say that maximum medical improvement should generally be reached within 2 years of injury. So that's in the guidelines itself. Now, practice pointer is at any point in a case, we can be talking to opposing counsel and to the claimant about trying to resolve the matter, and specifically a scheduled loss of use where it might be quite straightforward or quite small in terms of exposure or overall nature and extent of permanent residual disability. We would certainly want to be talking to our opposing counsel prior to 6 months elapsing. Now, MMI is based on a medical judgment, and you will often see a reluctance on the part of treating physicians. And by the way, I am winking in a very arch way. And when I say reluctance, I mean claimants picking physicians that are very unlikely to find that they've reached maximum medical improvement, right? Because in this jurisdiction, there's a game that goes on. There is no limit to temporary disability in New York, unlike other jurisdictions, which might say after several hundred weeks, perhaps, you've reached a degree of permanency. New York does not have that. And we also have claimants who will attempt to stretch out their disability. Sometimes instead of when we raise, hey, judge, this person's reached maximum medical improvement, they've been in active care for a year, they've been in physical therapy, they've reached a plateau, Your Honor, they have now reached MMI, we should move on to the permanency aspect of this case if there is any. Oftentimes you'll see claimants come forward and say, but wait a second, I need a surgery. Or that's the moment when they try to bring in additional body parts. So beware of those two things. When you're pushing hard for the case to be at MMI so that you can move on and close your file, just be advised that those are the things that they're gonna try to do. And these are the startovers, right? They'll try to seek some maybe unnecessary surgery in an attempt to start the case over and get their temp running again. Or they'll try to bring in new body parts. So just beware of that tactic, it's very common. When the claimant reaches maximum medical improvement, there is a form, because by the way, this is New York and they love forms, and it is a form C-4.3 that the air physician is supposed to complete to estimate their medical impairment. Now, if their physician, by the way, is completing this form and estimating a degree of permanent residual impairment, they are essentially conceding that the claimant is at maximum medical improvement. So please note that if you see one of these forms in your file, it means, hey, good news, I've got a potential case that I can move forward. All right, let's move on to our topic for today, which is scheduled loss of use. And remember, we've got to get the claimant to a maximum medical improvement, or curative care comes to an end, so that we can then start addressing permanent residual disability. Now, scheduled loss of use is a specific appellation of permanent residual disability that applies to specific body parts. What is and what is not a scheduled loss of use award? And this is kind of interesting. So in this state, there is actual case law that says it is not an award of pain and suffering. We're not supposed to consider pain and suffering. Instead, it is to compensate for the loss of earning power related to a specific injury and specific body part. It doesn't matter how much of time that the claimant has lost from work, the amount of compensation that they are awarded is fixed at a statutorily prescribed amount. And it is a legal determination that can be made by the board. Now, what's interesting about the case law that I explore scheduled loss of use is, it does not talk about impairment in their personal life. It talks about their impact on their ability to earn a wage or earnings. And as we'll see when we talk about how these the medical impairment is estimated, I'll show you that it is really quite rigid and mechanical how the scheduled loss of use finding is actually calculated. But the thing I do want to talk about is the fact that pain and suffering is not supposed to be considered, and nor is the impact on their activities of daily living. So when the claimant comes into court and says, hey, judge, I injured my hand, I had a fracture to my wrist, and my doctor says I have 30% scheduled loss of use of the statutory hand, you say, okay, but you're working at the same job, doing the same duty, full-time, no lost time. Maybe you're even working more hours. That's what the judge is supposed to consider. When they come in and they say, yeah, but judge, I'm not able to play ping pong as well. That's cute, but as you can see in the statutory construction and the way it's been interpreted by the courts, the claimant is only, their award is supposed to be based on their loss of wage ability or their ability to work and their functional impairment. That's what it's supposed to be based on. So we've got to keep the court focused on that and not let them travel off into other areas. Now, a scheduled loss of use applies to specific body parts: arms, hand, fingers, leg, foot, toes, eyes, hearing, and disfigurement. And section 15, subsection 3 of the statute is the statute that controls here. And we're lucky because the workers' compensation courts, the legislature 100 years ago set forward this schedule, which is the maximum number of weeks per body part: arm, leg, hand, foot. And as you can see, there is a capped number of weeks that are potential for the award. When I look at this list, I think that some things are overcompensated, but I do think that hands, fingers, toes, undercompensated. The idea that someone could lose their thumb in an accident and only get 75 weeks of compensation, me personally, I just believe that that's an undercompensation for quite a significant injury. And particularly in comparison to loss of wage earning awards in this jurisdiction, which are made for things like low back claims or psychiatric claims, I really believe that we are undercompensating people for hands, finger, feet, and toes injuries and dramatically overcompensating them for things like unspecified mechanical low back pain, for example. Again, that's just my opinion, that's my bias. But if I could change one thing in the workers' compensation law in New York, this would be one of the things that I would change. All right, so what's the litigation path for a scheduled loss of use? Well, again, take it as table stakes that the claimant has reached maximum medical improvement. Then both sides get impairment ratings. Now we can concede, we can decide not to get our own impairment rating, but the court is required to ask the treating physician to provide an impairment rating. If the impairment ratings differ, and by the way, they probably will, we are allowed to take medical testimony and the testimony of the claimant as to their working ability and the impact of these injuries. And finally, this will result in an award, which is for a capped number of weeks. Now, there's one wrinkle to this because this seems quite straightforward. I should also remark that when the scheduled loss of use award is entered, we do get a credit for all of the temporary disability that we've paid in the case, whether it is temp total or temp partial. But New York has one wrinkle, which is an interesting wrinkle, which is it has a concept called protracted healing period. And this is an interesting concept in that it was designed into the statute over 100 years ago. And the legislature back then, and again, think about the state of medicine 100 years ago, right? No such thing as x-rays, no antibiotics, right? I mean, really think about how crude and rudimentary medical treatment was 100 years ago. But back then, the legislature said, hey, we're going to set forward this schedule of disability, the amount of money you're going to get for each of these enumerated awards. But also, we're going to set forward a schedule, which is the protracted healing period schedule, which predicts how long the average person should recover from every injury. Let that sink in for a second. 100 years ago, legislature says we know how long it's going to take to recover from an injury to these body parts. And interestingly, they don't take into account the severity of the injury. So if the person has a shoulder sprain, the legislature estimates the same amount of recovery time as if they have a rotator cuff tear, much more significant injury, right? And so they set forward this schedule called the protracted healing period schedule of how long it takes you to recover from the average injury. And you can see on the schedule, the first one listed is the arm, and it says that's 32 weeks to recover from an injury to the arm. Again, it doesn't take into account A, advances in medicine, or B, the fact that different injuries are going to have different severities. Now, what's interesting about this is the legislature ruled that when protracted healing period applies, we're going to add additional weeks of compensation to someone's workers' compensation award. Essentially what they are saying is that if it took them longer to recover than the amount enumerated in this protracted healing period award schedule, you're going to add additional weeks to their workers' compensation award. Now, before we move on, and again, I want to just mechanically talk about how silly this is, the idea that the legislature 100 years ago could predict how quickly someone's going to recover from an injury to a specific body part. I mean, obviously they couldn't. But this also creates an incentive for the claimant to stay out of work longer. Because remember, you're going to get an award of, let's say, 100 weeks of compensation. But if you stayed out of work, in the case of an arm injury, for more than 32 weeks, we're going to add, and we have to, according to the statute, more weeks of compensation onto your award. So this really incentivizes and motivates a claimant to stay out of work longer because it's going to actually result in a larger award to them. So this is something to be really mindful of. I'll give you an example calculation because I know that was a little abstract. So let's give a specific example. Let's look at a case with a temporary total disability rate of $966.78 per week. The claimant has an injury to their left arm, and that is found to be a 35% residual impairment and a 35% scheduled loss of use. That would equate to 109.2 weeks of compensation, or $105,572.38. But looking back at the case, the claimant was actually out of work for 34.5 weeks of compensation. So while they were in active care and before they reached maximum medical improvement, they were paid 34.5 weeks of temporary total disability. Now remember, the legislature over 100 years ago said the normal healing period for an arm is 32 weeks. So what we would do is we would take the 34.5 weeks we paid them, subtract the 32-week period, and we would have to add onto this award an additional $2,416.95. So that adds to the gross award, which takes the gross award from $105,000 all the way up to $107,000, almost $108,000. Now, we are allowed to subtract the amount that we paid in temporary disability, but you can see how this increases awards, and it can do it quite dramatically where the claimant's been out of work for much longer than the healing period. So this is something to be very mindful of. I should also remark that you do get a credit for the amount paid in temporary partial disability and temporary total disability. And finally, the last thing I'm going to suggest to you, or I just want to impart, is that protracted healing period award only applies to weeks that are paid at the temporary total disability rate. And here's your second big practice pointer. This is why at Lois Law Firm, we never agree to a tentative rate in New York, because then when we go to resolve the case, the claimant can make an argument that all those weeks that were paid at the temporary tentative rate should have been paid at a temp total rate, which can result in a huge award for a protracted healing period. So that's something to be really mindful of. It's specific to this jurisdiction, and it can be a potential landmine in terms of really expanding your exposure in a New York workers' compensation case. So that's something to be mindful of. Now, we can also demand a right to credit for apportionment, and that's for any prior awards. Now, there is case law on the right or the ability of the carrier to assert their demand that they should be deemed apportionment, and they should have a prior scheduled loss of use to the same site deducted from the current award. What's great about this is that credit is paid in today's dollars. Doesn't matter, it's not a dollar for dollar credit, it's a percentage credit, which means you're going to get the benefit of that in today's dollars. So that's a very effective credit for you. Also, there is case law that says that the sub-members, you get apportionment credit as well for that. So be mindful about how to do this. Last thing I'm going to talk about is how to calculate scheduled loss of use. So we've already sort of touched on this in the protracted healing period example, but let's go through the calculation. It's the percentage of the body part, which gives you a number of weeks times their total temporary disability rate. That's their gross amount. Now, we do get to subtract the amount of prior indemnity paid, but remember, in the final formula you see on the bottom there is we have to add in those protracted healing period weeks, or PHP weeks. That minus the attorney's fee will yield a net award to the claimant. So let's look at some examples of this just to make this a little more concrete and a little less abstract. Left knee injury, average weekly wage of $1,050 will give rise to a $700 temporary total disability rate. Let's presume the claimant achieves a scheduled loss of use award of 25% of the leg. That equates to 72 weeks. Pretty straightforward to come up with and calculate what the gross award is. It would be the temporary total disability rate of $700 a week times the 72 weeks in the award, or a gross award of $50,400. Let's look at the same award with apportionment. A left knee injury, again, same average weekly wage, same scheduled loss of use of 25%, same gross award, but imagine the prior award was for 40% of the statutory leg. We would be allowed to reduce our exposure by 60%, which would yield a significantly lower actual total award. Temporary total disability is subject to a rate cap. So each year, as the rate caps move up and down, just be mindful of that. We are now in a situation where the minimum rate is going to move every December. The maximum rate is going to change every July 1st. And in fact, we are due next month for a new rate cap structure to come into play. All right, so we talked a little bit about how this is calculated, but now we should talk about how it's determined. So how do we determine the amount or the permanent residual disability that the claimant is going to be able to be compensated for in a scheduled loss of use? Well, we look to the disability duration guidelines. This was published, there's been multiple versions, but the one that we currently are using is the 2018 guidelines. These guidelines are organized by body part and structure, but I think it's important for us to look at the guidelines as a whole, because there's also information that takes place in the introductory area of the guidelines, which is important. And that's the guidelines about when a permanent residual disability can be determined. Again, remember the guidelines say at least 6 months have to elapse unless the parties stipulate, and when maximum medical improvement should generally be reached. The roles in determining the amount of disability. Well, doctors determine only impairment. It's a purely medical finding made by a medical professional. I'm going to talk about it, how they do that next. There must be a complete medical examination and accurate objective assessment. And we're going to focus on objective assessments. That's what we really want here. We really want to get a good idea of where this person's at. The judge is then going to determine the amount of disability. That's a different concept. we're talking about the impact of the injury on the worker's ability to work. And this is why, in combating some of the medical evidence that you're going to be confronting as a employer or as a carrier or as an attorney in this state, it's important to know, what is the claimant doing now? What are their current job duties? Have they returned to the same job? What is their current working ability? It's going to be some of the strongest evidence that you're going to be able to put together in order to challenge sometimes outlandish and huge scheduled loss of use findings. The disability duration guidelines also include specific methods by body part for how to determine impairment. And again, there was an attempt here to make this as objective as they possibly could. So as we go through some of the guidelines, I'm going to do an example of, we're going to look at it knee case. This was really an attempt to make this scientific and to reduce guesswork. Now, the entertaining moment, of course, is going to be two physicians examining the exact same claimant are going to have wildly different ideas about the nature and extent of permanent residual disability. And again, the treating physician, strangely, is always going to come up in general with a very high finding of permanent residual disability. And our evaluating physician, our independent experts, are usually going to have a much lower baseline. Why is that? Number one, claimants are choosing their own physicians. Are they choosing the best doctors? No. Are they going to the hospital for special surgery when they have a hand or foot injury? Absolutely not. They're going to a doctor that their attorney sent them to with the sole purpose of staying out of work as long as they can, stretching it out, or getting these huge impairment ratings. That's what they're doing. That's the game. We're going to be using independent physicians who are going to be a little less paternalistic and more objective. And I'm going to tell you right off the bat that our findings are going to differ from the findings of the treating physicians. It's also an interesting moment that the treating physician will often have a much higher finding of permanent residual impairment than our independent medical evaluator. And you ask, why is that? Like, you're treating this person. Like, do you have any pride at all? Don't you think that your treatment of them actually made them better, right? Or isn't it weird that after they treated with you after all this time, they got this terrible outcome and they have this terrible impairment? I mean, it's a very strange system to allow that to happen, but that's what happens. And the treating physicians are savvy to the game. So just be aware that's going to be, you're not going to see great alignment between two evaluating physicians. Now, the doctor's job is to evaluate the level of permanent residual physical deficit. In most circumstances, the board is publishing what they think a normal value for range of motion or strength testing or grip testing is going to be. The evaluating physician or the treating physician has to record their physical findings. They have to do a physical examination, and they must follow the guidelines. The guidelines also suggest that they should, require that they use a goniometer, which is a tool to measure active and passive range of motion. Now, deficits have to be measured by comparing the baseline reading to the unaffected side. So if someone claims that they have a right shoulder injury and they can't lift their arm above their head, well, the doctor has to look to the left side as well. They have to look to the other side. And if they can't lift their left arm over their head as well, well then, doctor, how can you say it's the injury that led to this impairment? Isn't it possible that just the natural effects of aging, they've lost range of motion in their rotator cuffs because they're old, or they didn't take care of themselves, or whatever, they're deconditioned, whatever the results could be. Some body parts, in addition to those objective range of motion findings, are going to have some special considerations, which really just means sort of bonus awards that are added to their award for specific treatment modalities. So let's talk about this a little more specifically. If you look at something like a shoulder injury, there is a very specific range of motion finding that the doctor is supposed to find. Again, they need to do an active range of motion, they need to use a goniometer, and they have to do it 3 different times to find the maximum range of motion. And of course, they have to compare it to the opposite side. But based on the loss of range of motion, the doctor is then going to apply an overall finding in terms of permanent residual impairment. So this seems quite straightforward and even scientific. Again, looking at something like a knee, and here's an example of using that goniometer tool to measure the range of motion. The scheduled loss of use really should be essentially the range of motion loss plus any special considerations. And for example, in the case of the knee, If you have a specific surgery, you might have a specific special consideration bonus added on top of your scheduled loss of use award. The doctor can then use a tool like this, which is the percentage loss of use chart, to determine the exact percentage of loss of range of motion and turn that into a finding of permanent impairment. Now, our best practice here is always to check the findings. Do they make sense? Where the claimant is picking their own treating physician to make their findings, are they possible? Did the doctor do what they were supposed to do? Did they use a goniometer? Did they test the opposite limb to make sure that their findings were not just the result of baseline degenerative changes? And the most important one is, does the claimant have worse findings in their permanency examination than they did during treatment? So, for example, if you read the physical therapy notes, and the physical therapy notes say, excellent result from physical therapy today, has regained 90% of their range of motion, is able to lift 15 pounds above their head. They're putting really good notes in there that are documenting that the claimant's having a wonderful recovery and that physical therapy is effective. And then they go to their examining physician the next week to get their permanency evaluation. And of course, now they say they have a 50% range of motion. Those things conflict. And that's an important contradiction, because it's going to show you, hey, when they're going to their evaluating physician to get their permanency evaluation, they're malingering, right? They're not being cooperative, or they're pretending that they're in pain and they can't move that body part. So that's a really important part of what we're going to do as defense attorneys in a cross-examination, to make sure we're not getting taken advantage of by those kind of concealments or malingerings. All right, how do we calculate the scheduled loss of use exposure, and how do we settle these cases? How do we close these cases? Again, the calculation is actually relatively straightforward once you have the evaluating physician's percentage of impairment. And again, you're going to compare that to the treating records. You're going to compare that to maybe surveillance you have done, perhaps covert surveillance. You're going to compare that to what they're currently doing in your workplace. If they're currently working for you and they're working well and they're, no restrictions, or maybe they were doing the same job and maybe they're doing more than they were doing at the time of loss, that's a good argument for judge there isn't any permanent impairment here. Now, both sides are typically going to get those reports, and we're going to exchange those reports. And as I said earlier, it's common for there to be a lot of disagreement in those reports. Most common injuries that we're going to see over and over again, rotator cuff tears, knee meniscal tears, ACL injuries, those types of things, are going to have a pretty prescribed or pretty common and pretty narrow range of impairment findings. And over time, those patterns will be obvious, right? Also, there are certain physicians who, I'm going to tell you, every time I look at their report, I go, okay, they're going to give us 60% on this one. They're going to give a huge number. But again, through experience, you learn, hey, here's the cross-examination that works with that physician, or here's where I need to go to the medical records. And we're going to tailor that cross-examination to either challenge the doctor's credibility or challenge their findings as non-objective, right? So we're going to do both of those things. Now, we don't just, when we do a scheduled loss of use case, we also should be thinking of, can we do a full and final? And a full and final might be a good idea, particularly where you have an employee who doesn't work for you anymore. So they're not going to have a re-injury. You're not going to be looking for apportionment, hopefully, against them in the future. So just consider that. When we're thinking about litigation risk and discounting settlements, I'm thinking about, what is this case going to cost to try? What's the likely outcome can be? I know in cases where my opposing party's demand is 100% or 100% scheduled loss of use, there is no downside to trying those cases, right? Because, unless it's an amputation, which would, again, be likely to give rise to 100% scheduled loss of use, really, there's a lot of gray area in there, and we should be mindful about it. Consider the value of right now money to a claimant. Sometimes you can push a case to settlement based on other factors, and those factors, I'll give an example of, is right now money. Here's a great example of that. I have a case in which my opposing party calls me up and says, hey, Greg, I need you to do something for me. Okay, sure, what can I do for you? I need a payment ledger showing all the indemnity paid in this case. And I said, sure, that's not a problem. Why? And they said, well, my client, the claimant, is moving and he's going to be buying a house. And so he needs to show all of his income information for the last 3 years in order to qualify for his mortgage. And he needs to show the amount of money he received from workers' compensation because the mortgage company wants to see that he did have that wage replacement and that it's ongoing and that they need to see that so that he can qualify for this mortgage. And I said, okay, thanks, no problem. I call up my client, and what do I say to my client? Hey, this guy's buying a house. I bet you he's really interested right now in getting some right now money. Maybe we could do this case by way of a Section 32. We could do a lump sum dismissal because he wants the cash to go put as a down payment on his house. And that worked out, right? So different claimants are going to have different appetites for some right now money. So just be mindful about that. We do use ATF tables to discount to present values. I'll show you them on the next slide. And we will also always consider an indemnity only if the future medical is likely to be very small. So I'm not against indemnity only settlements. Present value discounting, we do it. There is on the board's website a specific bulletin as to how this discounting is to take place. Internally, we have a tool that we use to help us discount these awards and bring them down to a present value that we know that they're going to resolve at. Now, let's talk a little bit more about exposure and resolving cases. I'm going to speak to the attorneys out there right now. We, as attorneys, as defense professionals, we should be recommending the amount of settlement authority. We should be asking for dollars, not percentages. I think nothing makes clients more frustrated than when they have to go look something up or figure out how to translate that percentage into a dollar figure. Let's give them dollar figures. We, as defense attorneys, we make offers and we make counter offers. We don't make demands, right? It drives me crazy when someone refers to the claimant's demand as the claimant's offer to settle. That's not their offer to settle, that's their demand, right? So I never want you to hear that from me. I never recommend paying total, really. Unless it's an amputation case, and I think I just briefly touched upon that earlier. You know, in those cases, there's got to be some gray area. If you're recommending total to a client, well, I don't think you did your job. I mean, well, how much worse could it get, really? What not to do, again, as defense counsel, I don't like it when attorneys talk like they're calculators. Well, 25% scheduled loss of use equals $100,000, 75% equals $300,000, give me some money. Like, nope. I also don't like giving clients ranges of whatever the authority should be. I like to say, here's what I think this is going to close at. I know that some of my clients don't want to settle some of these cases, and there might be strategic reasons for that. And the last thing is, again, we instruct our attorneys here not to ask for settlement authority in terms of percentages, but instead use dollar amounts. Make it simple for your client. Now, you're like, Greg, why are you telling me this? I'm not a defense attorney. It's because if you see any of my attorneys doing those things, please bring it to my attention because I want to fix it, okay? Because it drives me crazy. All right, how do scheduled loss of uses case resolve? Again, I love to push them towards Section 32s if they don't work for us anymore, but if they do, you can move by way of stipulation. You can stipulate to a scheduled loss of use, or you can try the case to conclusion and have the judge make a decision. Remember that there is a statutory maximum and minimum for these awards, and that's going to have the biggest impact on your overall scheduled loss of use. We should subtract all the prior temp paid, and I don't really ever trust the FROIs or SHROIs. Those are first report of injuries or subsequent report of injuries that are filed with the board. Sometimes the board's behind in terms of getting that stuff uploaded or placed into the electronic docketing system. So when we're going to calculate, hey, what's the amount of our credit, I'm going to want to get a payment ledger from my client directly. Now the board, of course, because it loves forms, does have a form for the parties to utilize when we are recording a scheduled loss of use stipulation. And in order to complete this, we're really just going to need the information that I've covered. What is their average weekly wage? What's the temp already paid? What's the percentage of scheduled loss of use? You know, we'll determine for you, hey, is there protracted healing period money that maybe we have to throw in? what's the gross to the claimant? What are the attorney's fees? And then in every single one of my stipulations, and I think this is the best practice. I just want to stay on this for 1 second to kind of talk about it. We always stipulate that our Section 29 rights, those are our rights to reimbursement from any risk transfer opportunities that exist, are preserved. And we do this even in cases where we haven't identified a risk transfer opportunity yet. Just remember, the workers' comp case hopefully is going to settle before maybe even the statutory statute of limitations has expired for filing that civil action. That's 3 years for bodily injury in the state of New York. And so for those reasons, we always want to put into our stipulations that we have the right to reimbursement or recovery from any civil action. So that's how we put these together. Now, I'm about to move into questions, so if you haven't asked your question yet, please type it in here. I would love to answer your question today. Key tactics, protracted healing period increases scheduled loss of use awards. So if you've never heard of that concept before today's webinar, it's a really important thing for you to take away from this presentation. Our job is not just to choose in the middle of two competing doctors. One's right and one's wrong, okay? So our job here is to advocate for the correct application of the disability duration guidelines, and hopefully one that's most favorable to our clients. I do not like it when my clients get taken advantage of. As your case progresses, as treatment progresses, exposure value of this case is going to go up and down, and our job is to make sure that you, the client, are aware of what's happening. Some other takeaways. Every step in this scheduled loss of use determination process, that's an opportunity. We should be talking about resolving these cases, not at the end of the cases. It's too late if you waited, right? As we're challenging the nature and extent of scheduled loss of use or protracted healing period, as we're taking the testimony of opposing physicians in the case, each one of those steps, that's when you should settle the case. We should be happy that we settled the case or resolved it after taking a single deposition. We don't need to go through this entire process. So leverage the process, use the process to create those opportunities to actually settle. It's also important to identify who the stakeholders are. Hey, if you want to settle early, we're going to need settlement authority early. We're going to be talking about this stuff early. So who should be in that call? Who should be in that conversation so that we can make sure we can make these cases move forward? All right, let's jump over to the questions, and I'm hoping I've got a couple good ones so far. Okay, there are a couple questions in here. All right, so Valentina says, Greg, is there a presentation? My window says it's waiting for Greg Lois's screen. Oh gosh, I really hope everyone was able to see this whole thing. It was really good. So Valentina, I'm hoping that's just a problem for you, not for everybody. All right. Miguel says, Greg, let me just open this window. This is a long question, so I want to read it correctly for Miguel. He says, Greg, in situations such as where the claimant had an IME scheduled by their attorney and the impairment found is wildly different or higher than the treating provider, would it be better for the carrier to assert its rights under Section 310 and enforce the Lazuli versus Wegmans and proceed with the record rather than seek its own impairment opinion and risk the IME's agreeing? Okay, so Miguel, great question. So Miguel's question is this: Greg, they have a treating physician, but then they go out and they get a different doctor to give the impairment rating, and it's wildly higher than the treating provider. And now they want to rely on that, okay? What should we do? Should we go with the treating physician, which is lower, but again, we're going to probably expect it still to be higher than a true defense medical expert, or should we challenge it? What should we do? So a couple things. First, where the claimant goes out and gets their own medical expert, that's not the treating provider. Please note that all of the requirements of Section 137, those are notice, preparation of the record, communication with that doctor, all have to be observed by the claimant's attorney. We have to treat it like a true independent evaluator. If they've observed all of those things, then my advice would be generally, let's go out and get our own independent expert. You're not going to do worse. They clearly chose that physician for a very specific purpose. I also suspect you'd be able to draw a Section 137 violation or preclusion and use their expert, the way they prepare their expert, as an opportunity to attack the credibility of that expert. And I would also tell you that when I would cross-examination, if I was cross-examination, your expert, I would probably be asking them about their resume, their places of study. I would ask them how they get paid, who they share an office with, what's the referral relationship with the treating physician, what's the referral relationship with the attorney that referred them the case, what communication did they have with that attorney, was any of the communication not in writing, were there any medical records? I would go deep. I would spend most of my cross-examination, probably at least half of it anyway, talking about all of those issues to try to move to preclude that IME doctor. So that's how I would probably approach that. So I hope that's helpful to you, Miguel. All right, Christopher says, Greg, are full and final settlements still off the table in New York, i.e. settle and separate employment? No, you can absolutely do those. We do them as a matter of course. You can still do resignations. The Section 32 cannot be contingent on the resignation. And now, for the last 2 years, we have to identify that there is a resignation. If there is consideration paid in furtherance of that resignation, we have to state that in our Section 32 settlement documents, specifically the Section C-32 affidavit that we have to complete. But it's not impossible. We should do them all the time. Resignation should be a regular part of your Section 32 practice in New York. Kimberly says, Greg, what conditions or priors can be apportioned? All right, so in the presentation, I specifically talked about prior workers' compensation awards. Those are the easiest to get apportionment for because it's in the case law. It says you should get apportionment. In fact, it says shall, right, not may. So those are easy. But what about non-work related injuries? What about congenital conditions? What about football injury that happened to the claimant in high school, or volleyball injury or something? You can make a pitch for all of that. Now, there is going to be case law that's going to say if it didn't impact their wage earning ability, then it really shouldn't be considered as a pre-existing condition, as a subject to a credit. But I think that that's part of our jobs as advocates, right? We've got to make that argument, say, well, Your Honor, actually, it did impact their wage earning ability. Here's how, and I think that it's possible. So although there is black letter law, case law, precedent, which says if it didn't have an impact on their wage earning ability, then it shouldn't be considered for terms of apportionment or credit, we still raise them. I think that's part of being a good advocate and seeing what the claimant testifies about that. Hey, you didn't take as much overtime because you already had this pre-existing condition. If they say yes, that's self-limited and that's limiting their earning ability, great news, right? Now you've just established your right to apportionment. So I think that's one of those moments where you've got to argue and advocate. Okay, Lowell says, Greg, can you clarify how you determine indemnity-only Section 32 offer on a cap case, specifically your present value weeks discount on the value of the remaining capped weeks? Yeah, so in an LWEC case, loss of wage earning capacity case, I just use the present value calculator. I calculate it down. I say, here's what the offer is going to be, right? Because I know it's black letter law. It's simple. But in a scheduled loss of use case, where we might be talking about stacked weeks or weeks, I'm still going to use a present value discount if I'm going to do a lump sum on those settlements. And my adversary could say, but Greg, you're not entitled to that because I could go and I could stipulate to the number of weeks, and you have to pay them as a lump sum anyway. Okay, that's an argument position they can take, and I get it, and that 9 times out of 10, that might be the argument. But again, I'm always looking for an edge, and I'm always looking for an opportunity to try to save my clients a little money. So I am going to try to present value discount those cases. To me, the value of doing an indemnity only, even when there's a capped award, and even when we would have to pay the award all at once, is for my clients, it's full and final, right? There's no potential of reopener. Under a Section 15 scheduled loss of use stipulation, remember that is subject to a reopener. Under Section 123 of the Workers' Compensation Law, the claimant has the right to modify or bring that case back should their condition materially worsen. So I do want to protect my clients from that. So even in a scheduled loss of use case, I'm going to be searching for an opportunity to do a Section 32, particularly where the claimant no longer works for the insured or the employer. That's the ideal scenario to do that. So I hope that was a helpful answer to you, Loa. All right. So I think those are the questions we had, and those are great questions, and I'm really glad that we had those questions. Thank you. That's what makes this more fun for me and the participation for you more meaningful. Some other things as we sum up here. Please, if you're not part of our email newsletter, check out our newsletter. We are constantly talking about wins and the ways we're pushing the law forward in New York. Check out our podcast page. We publish 3 podcasts a month on different topics in workers' compensation law. And if you like podcasts, and it's the summer season, right? Like you're going to be down the beach with your toes in the sand and you need a good podcast, check out my partner, Christian's podcast. It's called Third Fridays. It is about workers' comp topics. Really great. Always release the 3rd Friday of the month. So please check that out. All right, everybody. Thank you so much for joining today. I hope this was useful for you and I hope you got something out of it. Have a great rest of your month, and I'll see you in July.